When I was a medical student, I spent countless hours learning biochemical pathways like the Krebs cycle. And now, years later, as I'm accepting my first position as an attending anesthesiologist, I realized that I spent exactly 0 hours learning about job contracts for physicians. So I hired a lawyer, and at the end of working with him, I said, "Hey, do you want to be interviewed on my YouTube channel?" And to my surprise, he said, "Sure." So in today's video, we're driving to upstate New York and talking with the attorney who helped me negotiate my first job contract as he shares some pearls of wisdom for physicians who are negotiating their job contracts.
My name is Chuck Assini, and I've been representing a physician anesthesiologist for over 35 years. And I also serve as the New York State Society of Anesthesiologists Legislative Counsel. And as a result of my practice, I've done a lot of work with residents and attendings with their career choices and contract reviews.
The capacity in which we started working together was that I was looking for a job and identified an opportunity that I'm really excited about and wanted to have an expert set of eyes looking over my offer letter and my contract, because I'd never looked at a contract before, where I thought that we could start really at the top, just big picture idea about contracts for physicians. What sort of career options do physicians have in terms of what their practice settings look like? And I'll just start it off by saying, when I was in residency, I thought about private practice and academics. And those are basically the only two practice environments that I could think of.
Right.
What would you add to that?
So private practice, then you have the exclusively owned, then you have these national groups that are private equity based, you have the academic, you have the large health systems, and then you have the regional hospitals, and then you have locum tenens and independent contractor relationship agreements. So there are many career options that are available. With respect to private practice, you have to remember that there are groups that are exclusively owned by physicians, like the LLCs or the PCs. But the evolution, at least in anesthesia, is that equity ownership is becoming more prevalent. So there are many large national practices that are underwritten by private equity. And that represents different issues for you to take into consideration. Again, who's your boss? One thing that is happening in the marketplace are consolidations and mergers. So if you're joining a large national practice and they take over a practice in another state, you may be asked to relocate. So that's something that you don't really think about too much, because that really wasn't as prevalent even 5 years ago. But now the evolution of these consolidations and mergers, both with private equity groups buying physician-owned practices and hospital mergers, you may be required to relocate. So that's a provision in a contract that you need to be aware of. If you want to stay in one location, you have to make that a negotiating point. Healthcare systems, which Kaiser or Northwell, New York, which are very well managed, well run, their ability to keep up with marketplace trends, to have a well-oiled department and make things operate smoothly. I think those are important considerations when you're looking at like a large health system. Those are some of the advantages. The other employment options are regional hospitals. There are some really great opportunities for my clients. They've really enjoyed working in a small regional hospital. They're part of a community. They're working with the CFO and the CEO of the hospital. That's who they're negotiating with, but they do have a department chair. The other practice options are locum tenens, which are becoming, in terms of economics, you can generate a lot of money working with a locum tenens company. There are some considerations with locum tenens. One is you have to provide your own health insurance, you have to pay estimated taxes and self-employed taxes, and you really need to have an accountant help you navigate that. Independent contractor relationships, which some refer to as kind of moonlighting, those are other options that are available now as in terms of a practice option.
What are the different factors that your clients are typically considering when they're looking at a job contract or considering different offers?
What are your career objectives? Achieving a work-life balance? What I mean by that is, do you want to have a position where you are working 70 hours a week, you're engaged, the academic setting, which you know very well. Not only are you doing clinical work, but you're doing grand rounds, you're teaching. Even if you're not on tenure track, you're still involved in that academic community. And that's very rewarding for a lot of my clients. They really gravitate toward that. They've enjoyed it. You're working with very skilled physicians and mentors. The other kind of career perspective is, do you want to maximize your compensation? Do you want to have a position where you look at the offer letter and say, I want the biggest base compensation, I want the biggest sign-on bonus, I want the biggest retention bonus because I have a lot of debt to pay, I'm willing to work hard, but I really want to maximize compensation. I've had other clients that are concerned about doing too much call. So they've gravitated toward positions that don't have call, don't have weekends, maybe not as much compensation, but it does achieve that work-life balance. Mm-hmm.
In your experience, how negotiable are contracts that your clients see? Because one of the conversation topics that came up amongst my friends, people who graduated with me, was I was given a contract and was told this is not negotiable. Right. But that was just a small slice of people who I spoke with. So I'm curious, in your experience, how negotiable contracts are in general.
One reason why some attendings don't reach out to an attorney because they've been told it's a take it or leave it proposition. Many contracts have your standard terms and conditions, but with that, they have an exhibit or an attachment that sets forth maybe specific duties, may set forth compensation terms like the retention bonus or the sign-on bonus. It may have other provisions in that attachment or that exhibit that are more open to negotiation. Standard terms and conditions, you're not going to likely change the term and termination provision. You're not going to change the requirement that you assign your billing rights, that you're not going to change the non-competition provision. Those, because once they change it for one, then they feel is going to result in the need to change it for others. But with some of the material financial terms or duties, that may be an area that are more open to negotiation. I think also with any contract, words matter. So you have to understand what you're assigning. So although you may not be able to negotiate a provision, in discussing with people that you went to medical school with or did your training with, to find out exactly how things work. So for example, one is the on-call schedule. Some groups are very particular about, okay, it's call schedule, this is it, and if you achieve that threshold, extra pay for extra call. Some groups are very reluctant to be explicit about the call schedule. So what you need to know is, what are the normal hours? What is the call expectation? Is it every other weekend? What is your sense of how the call schedule works? And that gives you the, kind of that inside information. Even though it's not explicit in the contract, I have enough good information that I can make an informed decision that the call schedule is not going to be over the top. The other thing I'll mention with contract negotiations, and I've seen this with some of my clients recently, they know that in certain specialties there's a shortage. And so certainly that's true with anesthesiologists. So they may look at 2 or 3 different options at the outset. And even though you have to be careful when you sign an offer letter, whether you make sure it's not binding, because sometimes it is, but they conduct their due diligence and start to compare and say, gee, are you willing to negotiate this? Oh no, you can't. Are you going to bend on this? No. And all of a sudden now they have another option that the group they're negotiating with is a little bit more open-minded. And as a result, they're not kind of stuck 6 months into the process and say, gee, I wish I had looked at these other options at the outset. So that's another, consideration is, look at more than one position, and try to. I know it's time consuming, but try to open yourself. Give yourself the advantage of having more than one option available to you.
What are some other pitfalls that you would flag for people to try to avoid as they're getting into looking at different job offers that are out there?
I think one is because the marketplace can be competitive, some groups or recruiters will impose artificial deadlines. They'll say, if we don't hear from you by X date, we're going to withdraw the offer. Some of my clients have said, gee, I should have reached out to you sooner, but I have to decide tomorrow. No, you don't. You probably can get at least another week in terms of making sure you're making an informed decision. The other is not taking the time to, as referred to as pre-contract due diligence, to talk to not just the department chair or the recruiter. Try to talk to other people that are actually working in the practice. That will give you a better sense of how it runs and how it operates, and is there a sense that everything is kind of working as planned. There are provisions in contracts that, as I mentioned, are intentionally vague or intentionally omitted. Something I see almost all the time. Malpractice insurance. We will provide you the same malpractice as the other employed physicians. You read that and say, what's wrong with that? Well, I'm getting what everyone else is getting. The problem is you don't know what you're getting. You don't know if it's claims made or occurrence. You don't know what the limits of liability are. You don't know if you have the right to consent before settlement is entered into. You don't know if you're going to be assigned your own dedicated defense attorney. So that's an area where, yes, it's a red flag in that you can drill down and obtain additional information. I just looked at a contract where the first $1 million was self-insured, and then there's an excess layer of $7 million. Well, how does that work if you're named in a lawsuit? And so those are questions that you may have to ask the risk manager, or you may have to ask some other folks in the group. Different term and termination provisions or termination provisions. Some groups want to make sure that you give 180-day notice. They may want to be able to immediately terminate you. I understand if things aren't working out, they want to cut their losses, so to say. But that's something else to look at in terms of whether that that's a potential red flag. The other is with billing, there's a term called indemnification. Indemnification is a contract term which means, in essence, shifting risk from one party to another. Every contract will require you, or almost every contract, if you're, joining essentially any group, to assign your billing rights to that practice. You also probably will have to comply with their billing compliance protocols. You may have to execute a code of ethics. You may have to go through training. Many components of billing that you have not really been taught in your residency or your attending positions. You may need to know how to code. If you don't take those responsibilities seriously, and there's an audit by a government agency or even an internal audit, and they determine in their own discretion that your billing records were not timely, that your codes were incorrect, that they can impose cost on you. They can shift the responsibility from the group onto you to pay pretty significant fines and penalties. So I always advise my clients, don't be the low-hanging fruit. When you first start, you ask a million questions, you email the billing consultant, you say, are my billing records accurate? Do they look good? Is there anything else I can do? Because that way you will protect yourself going forward. You have a lot to do when you first start, but making sure that you know how to bill, making sure you know how to complete your billing records in a timely fashion, it's really important. I just looked at a contract where they could retroactively reduce your compensation if they determined that you were not in compliance with their billing plan. The other I would say is non-competes. California restricts non-competes. They ban non-competes. The governor of New York State vetoed a non-compete bill. The FTC is looking to ban non-competes. But right now, in many jurisdictions, are alive and well.
Can you define, in very basic terms, what is a non-compete?
Yeah. A non-compete stands for the proposition that if there's any termination, regardless of the reason, you may not compete with the group that you have been employed with, which means that for a period of a year or 2 years, you may not work at any practice location where they may have a contract or where they provide services. And some non-competes have a radius restriction saying not only can you not practice at those particular sites, but any site within a 5 or 10 mile radius. In New York City, they do it by street addresses because there's so many practices that could be impacted. A non-compete has to be reasonable. A non-compete has to be, it can't be so egregious that it would restrict you from earning a livelihood. Having said that, to go through a challenge of a non-compete becomes very expensive, and oftentimes, you may or may not be successful. With anesthesia, you don't, other than a chronic pain practice, you don't really, you're not taking patients, you're not taking surgeons, but there's still in almost every single contract I look at, including academic appointment letters. So non-competes, non-solicitation, just make sure that you understand what you're getting into before you sign the contract.
Two of the terms that I think it would be really helpful if you can elucidate are offer letter and contract, because they're not quite the same thing, but they're related.
It's a really good question in that, when you are working with any group, typically after you go through a series of interviews, there will come a point where they'll say, we'd like to offer you a job. We're going to send you an offer letter. That offer letter is usually what the compensation is, generally speaking, what the duties would be, term and termination, kind of just that basic information. And most offer letters will say, this is not a binding contract. This offer is contingent upon us agreeing to a more formalized contract, which is the second part of your question. So once you sign the offer letter, then you'll get the employment agreement. Some groups will not share their policies and procedures, which you are going to have to comply with when you sign that offer letter. I'm not sure why they claim that they're somehow confidential. If you go to an academic website, you can probably find them, but some private practices, they may not provide those to you. So that's something else that you need to be aware of. Should also mention that in addition to an offer letter, employment contract, you may be required to sign other agreements, or there are other agreements that you may be obligated to comply with. So if the group has a billing consultant agreement, even though you're not privy to that contract, you're going to have to comply with that contract. If the group has what they call an exclusive service contract, that's an agreement between the group and the hospital to provide all the services of that particular specialty. Typically it's radiology, pathology, anesthesiology, but they have like exclusive right to provide all those services. That exclusive service contract will impose upon you certain compliance obligations, so you need to know what those are. There may also be promissory notes. There may also be what they call powers of attorney to assign your billing rights. So there may be additional contracts that you may need to also execute or be compliant with.
You had mentioned the term equity position. Can you elaborate on what that means? How does an equity position compare to a non-equity position?
Right. So if you're joining a exclusively owned, physician-owned practice, after 3 or 5 years, you would then hopefully be made a partner or an equity owner. Many advantages to equity ownership. You share in the profits, so you generate a lot more revenue, more job security. You have access to the books and records of the entity. There may be certain criteria that you need to accomplish. Board certification is kind of a basic one, but there are other subjective criteria. I kind of refer to it as, the president of the group has, is on call on a weekend when their son or daughter has a big event, and they ask, will you take my call schedule? You need to probably think about the implications of saying no to that because when that equity ownership vote occurs, that's going to stick in the back of that president's mind. The other component with equity ownership is how the buy-in works. What we refer to as sweat equity, which means that for the first 3 or 4 or 5 years when you're not an equity owner, you're going to get paid significantly less than other employees even. And then after 3 or 5 years, that differential in salary represents your buy-in. And so you need to understand how that buy-in formula may work. I've come to know a president of a very, well-run private practice in Long Island. I said, "Are you offering equity ownership?" And he said, "You know, people I'm interviewing don't want to be equity owners because they want their money up front. They want the highest compensation. They don't want to have a reduction in their compensation. They don't want to go through the buy-in because they don't know what's going to happen in 3 or 5 years. They're fearful the group may get bought out. They're just not certain." So it's really been a kind of a shift, but that's just with anesthesia. There could be other practices where equity ownership is very much an important consideration when you're looking at a career option.
You had mentioned malpractice, which I think for a lot of people can kind of be the elephant in the room when talking about some of the financial aspects of being a physician. What do you see about how malpractice is baked into contracts, and what should physicians be thinking about in regards to malpractice?
If there is a malpractice action, importantly, you'll be signed, hopefully, a very skilled defense attorney. And that gets into, is it a dedicated defense attorney, or is it the defense attorney representing the other folks in the surgical team? So that's one important consideration. But legal defense is very expensive. Some malpractice cases last 6, 7, 8 years. Limit of liability. So New York State, 1.3 million per occurrence, 3.9 in the aggregate. So that means the most they're going to pay or settle a case would be 1.3 million. The most in any given year is 3.9. There is an excess, or kind of referred to as umbrella insurance. That's an additional 1.3 and 3.9. So you need to know what your limit of liability is. You can maybe even purchase some additional malpractice insurance at a cost. If you're in a high-risk specialty, adverse events can happen. There may not be any malpractice, but there could be exposure, and this gets into that consent issue. Because these cases are expensive, the entity or the company may say, "Yeah, we understand that your position is there has been no malpractice. I did everything according to my reasonable care." Most contracts don't instruct you whether you have the right to consent to settlement. That's an important consideration. And you want to know whether in advance, if there's a settlement, do I get a say in that? If you're going with a private insurance carrier, and even many of the risk management groups, they have two insuring clauses. Claims made or occurrence. Claims made is more limited, more restricted insuring clause. If you have a claims made policy, you have to purchase something called tail coverage, also referred to extended reporting endorsement.
And for those who don't know what tail coverage is, what's the one-liner?
What it means is, for any malpractice type of incident that occurs while you're employed, after you leave, when the actual summons and complaint is filed, that tail coverage will allow you to continue to have malpractice insurance. That's another area where the contracts are not particularly explicit. The way tail insurance or claims made insurance works is each year the insurance carrier is assuming more risk. So year one, the cost of the tail is going to be very modest. By year 6, it tends to balance out. That could be pretty expensive. I had a client several years ago, the tail insurance was $60,000. He had to pay that within 30 days, or he was in breach of the contract. Not only did he have to pay it because of the contract, he had to pay to make sure they had malpractice insurance, because some cases are interposed or filed 2.5 years. Statute of limitations with children, it extends another 10 years. So it's not a matter, even if the contract says you don't have to buy tail, if it's claims made, you have to buy the tail. So you have to negotiate that who's going to pay for it and what the formula is. If it's occurrence, it makes no difference, when you leave, if the claim is filed 10 years after, you're going to have insurance. But with claims made, if you don't have that extended reporting endorsement or tail coverage, you have no insurance.
So, for example, that could be someone who, say, retires at age 55. A lawsuit is filed when they are now 60 years old and they haven't been in practice for 5 years.
Yeah.
And if they have the tail coverage, then they have insurance.
Yeah, and most insurance carriers, if you're permanently disabled or permanently retire, you don't have to pay for the tail. It's kind of like built into the policy.
One of the points that you had mentioned earlier was about the terms and conditions of a contract. What does that mean?
This gets into kind of letters of appointment with academic institutions. So some have 1 year appointment, some have 3 years. What is the reappointment process? How does that work? So you get an offer letter that says this is a 1 year appointment. What happens after 1 year? Do you go through a reevaluation? Do you go through something more formal? There's a concept called at-will termination, which allows not so much the academic appointment letters, but with private practice, either party can terminate by simply giving the other party a written notice. That could be 90 days, it could be 180 days, whatever it may be. And again, some contracts allow the group to have immediate notice of termination, and that's something, a bit of a red flag just to think about because it would impose a hardship on you. Now, with academic appointments, some only permit termination what they call for cause, which means they need to have a reason why they are terminating the physician. But if you don't know how the reappointment process works, you could, after 1 year, they may say, yeah, we're not going to renew your contract. Well, your appointment, well, what do you mean? Well, we don't have to. So you need to look at those two terms together. Compensation and benefits should be read together. Generally speaking, academic appointment letters, compensation may be a little bit lower than some of these large national practices. But the benefit package could be significantly better. Compensation, different types of compensation packages or stated compensation. One would be your compensation is $450. It's going to be adjusted each year by an incremental increase, $450, $475. And that's one approach to compensation. The other would be a productivity-driven compensation system. And tied in with compensation and benefits are, I refer to retention bonuses and sign-on bonuses. Because the marketplace in anesthesia is so competitive, some of the large national groups are looking at significant sign-on bonuses and pretty significant retention bonuses. $50,000 sign-on bonus, $100,000 retention bonus for the next 3 years. What you have to look at is what triggers your repayment obligation.
Repaying meaning money that the physician has to return back.
That's correct. So if they paid you in advance, that retention bonus, and the condition is you have to, we'll pay you the next pay period, but if you don't work the entire year, there's going to be a return of that revenue that you achieved. One would think the only way that would trigger a repayment would be if you elected to leave. But you have to look at the term and termination provision or the termination provisions. It could be that if your contract is terminated, period, doesn't say if you leave, only if your contract is terminated, you have to repay. Some national groups say if we lose our exclusive service contract with the hospital, your contract terminates. You have no control over that. So you may say, well, that's not fair. I have to repay this bonus because the exclusive service contract was terminated. What the groups will say is, we will reassign you to another hospital. And you may say, well, where? I mean, when you say reassign, again, it gets back to if you bought a home or you wanted to stay in a particular location. So it's a little unsettling in terms of how some of these repayment obligations may be triggered. A lot of times duties, certainly with anesthesia, they're not going to say you're only going to work 7 to 4. They're going to say normal working hours. So that's where the due diligence comes in. What does your normal day look at? What is a call schedule? Those are important considerations. And again, some groups are very explicit about their call schedules. Others are not. I represent a group, and we went around and around in terms of how we could present as an exhibit to the contract the call schedule, because it needs to change based on the volume. It needs to change based on the demand. So there are going to be some nuances in how that is presented. I mean, I wrote that, so I know it gives us flexibility. So that's something that you want to keep in mind. With academic, what I find very interesting with academic appointments are how detailed the duties provisions are. As I mentioned, doing grand rounds, doing some, teaching and instructing, making sure that you are on a committee, things that many of my clients really want to do because it's part of that academic environment, which is, when you're looking the agreements I've looked at, the appointments, the Columbias and the Sinai's and the Cornells and the Stony Brooks, and they're great institutions. So you want to be part of that team. By the way, with benefits, I should mention, like Columbia offers tuition remission, which I thought was remarkable. Which if you think about college planning,
This is tuition remission for
their kids.
children.
Yeah,
Yeah.
yeah, which is a tremendous benefit. It may require that they go to a particular school, but nonetheless, a really, really great benefit. I mentioned for cause termination. So term and termination at will means they don't have to give a reason why they want to separate. They just simply give the notice. With for cause termination, one easy way for a group to terminate for a cause is if you're not compliant with a billing policy, or if you're not compliant with the department policies. Basically, if they document, for 2 weeks, we've given you warnings and you still haven't complied with these basic policies and protocols, they can then terminate you. And again, termination is no fun. You may be subject to a non-compete. You have to start the whole process over again. So my advice is make sure you know what is incorporated into your contract. Make sure you secure those policies, procedures, guidelines. Look at the bylaws. The bylaws provide important due process protection. You want to know about that. If a patient complains and there's a procedure that is triggered by an adverse patient outcome, and you get a notice, saying you must appear before the medical staff or whatever it may be, make sure you understand what your rights are in accordance with the bylaws.
Up till this point, we have spent a lot of time talking about considerations for, I think, really any physician who's looking at a job contract. But I would like to shift focus to anesthesiology. So for any future anesthesiologists who are watching this video, some topics that may be more specifically relevant to them. And so one of the first questions that I had was about current marketplace trends. So right now it's April 2024. And I think it's safe to say that you probably have your finger on the pulse, maybe more so than anyone else, with regards to what market trends look like regionally, perhaps nationally. And I would be curious to have you just speak to what is going on in the anesthesia job market right now.
Well, clearly there's a shortage of physician anesthesiologists. There's really a shortage of certified registered nurse anesthetist. 21 or 22 states now recognize anesthesiologist assistants. Groups are looking to make sure that their compensation packages are competitive. As I mentioned, the attorneys and the MBAs and the hospital administrators that draft these compensation packages are doing so, first of all, to protect their investment. There are contracts that say, if you don't achieve certain metrics at the end of your given year, we can reduce your compensation. That starting salary may seem very high, but you need to know how that can be reduced or adjusted going forward. The other advantage of this, competitive marketplace is it gives you the option to pursue avenues that maybe 5 years ago you may not have thought about pursuing. I mentioned academic appointments. Maybe programs that maybe you thought, or maybe 5 years ago were a little bit out of reach, may not be out of reach because there's a shortage. So that's another advantage. So I think that the marketplace, I don't know where the ceiling is going to go. I don't know if it's sustainable to keep on bumping up these compensation packages. And one thing with the anesthesia marketplace, that's why there's this consolidation, these large group practices, because they have more skill in negotiating reimbursement rates. Having said that, they're under more scrutiny by the federal government. So, and when you're joining a large national group, you're losing some control over your practice. So again, higher compensation, they may be better positioned to kind of deal with the anesthesia marketplace trends. There's also pressure on performing more and more cases, not just in the OR, but ambulatory surgical centers, maybe private practice settings, endoscopy centers. So, groups and the entities are getting spread pretty thin. That gets back to your normal workday, kind of no free lunch. I mean, you may be working much, much harder. even though that offer letter seems very nice, again, you need to understand that there's going to be maybe some pressure to work some additional hours.
In most fields, it's typically taboo to talk about compensation, specific numbers, comparing that amongst employees. But as I graduated from residency and my friends and I have been looking at job contracts, I think, part of us have wanted to share what the numbers look like in terms of offers so that we can just have a sense of what's out there, and is the offer that I'm looking at competitive? Is it not competitive? And so the question that I have for you along those lines is, to what extent do you think it's helpful or not for physicians to be discussing their compensation amongst each other?
Well, two things. Number one, there are surveys that are done by companies that you have to pay a fee, and they will provide the regional and specialty compensation ranges. The other thing to keep in mind is the offer letters typically don't say or restrict your right to talk about the material terms and conditions. Your contract may have a confidentiality provision, just to be aware of. So they may want to restrict you from making those comparisons. Another way, I think, is if you're at an AMA or the PGA or ASA exhibit hall, you can walk around and the recruiters are going to tell you what they're offering. And so that's another way of securing and getting a sense of what the marketplace is offering right now.
Well, in the time that we've been talking together, you have taken my knowledge about contracts from basically nothing to the level of me having signed my first job contract. I greatly appreciate it, and the time and expertise that you have offered on the YouTube channel. If people would like to get in touch with you to hire you to work with them in their contract, what's the best way for someone to do that?
Yeah, my email address is chuck@asinilaw.com.
I'll leave a link in the description for how people can find you on LinkedIn and your email address as well, in case anyone would like to be in touch. I greatly appreciate your time.
My pleasure, Doctor.